Hi everyone, I'm HB. I use they, them pronouns, and I'm a staff attorney at Public Counsel. And I have AC on in the background. I don't know if it's too loud. Okay, cool. Amanda?
Hello, I'm Amanda Sheft. I work with Immigrant Defenders Law Center and I oversee our Deported Veterans Legal Services project. And we also do post-conviction relief for deported veterans.
Great. Thank you, Amanda and HB. And a big thank you at the get-go to Ellen Miller, who's on the line. She manages our pro bono relationships and work at NIJC, and I know has been in touch with a few of you on the line. So today we're just using this time to talk to you about the work that we have been doing to bring home deported veterans using humanitarian parole. And the hope is to train you, all of you who are on the line, on the context in which this work has arisen, why there's such a critical need for this kind of representation right now, and then especially on the nuts and bolts of how to do this work, how to put together humanitarian parole applications, and to help bring home deported immigrant veterans. So in terms of an agenda, in a moment, we're going to play a 5-minute video to give you all just, to set the tone for us for today and for this work. And then, I will give some background on our work at NIJC to bring home unjustly deported people with the focus on veterans and the work that has been done on that front. And then I'll turn it over to my colleagues, HB and Amanda, who will walk you through the nuts and bolts of representing clients in this posture who are trying to return to the United States as deported veterans. So just before we play this video, so the video we're playing is a 5-minute testimonial from a veteran named Howard Bailey. He was deported in 2010 and lived essentially in exile in Jamaica for 10 years. He served in Desert Storm. He was a service member with the US Navy. And you'll hear in his words, how and why he was deported, and what that meant for him and his family, and about his fight to return home. And then, when he's done, I'll kind of fill you all in on the details of how we were able to successfully bring him home last summer. So Ellen, if you want to hit play on that, that would be great. And hopefully everyone can hear.
Yeah, just let me know if you cannot hear, please.
Absolutely. I can't hear anything, Ellen.
Let's try this.
Discharged veteran of the United States Navy.
Yep, that worked, Ellen. I'm going to go on mute now.
Hello, everyone. My name is Howard Bailey. I am a honorable discharged veteran of the United States Navy. I served in both Operation Desert Storm and Providing Comfort. I joined the military right after high school to serve my country. I have now been living in exile for 8 years, 10 if I include the 2 I spent in immigration jail fighting my case. Before I was deported to Jamaica, a country I have not seen in 25 years, I was a happily married man with 2 American kids, a home I purchased with my VA loan, owned my own trucking business with 4 employees, and paid my taxes. In my mind, I was living the American dream. The last time I saw my home was in June, 10 years ago. And since then, life feels like a total nightmare. Every day I hope and pray I will make it. I will wake up and I'll be back home in Virginia again. In 1995, about 6 months after I got out of the military, I was charged with possession of marijuana. I was 22 years old at the time. It was my first time ever being arrested. I didn't know that I had marijuana being delivered to me in a package. I told the cops and they said not to worry. But I still had to go to court. My lawyer told me this is just a slap on the wrist. We're just going to plead guilty. Being young and naive, I listened. 25 years later now, I'm still paying. In 2010, 15 years after I was arrested for the marijuana thing, I surrounded my home and came to take me away because I was too honest. You see, I applied for US citizenship, and when the application asked me if I ever been convicted of a crime, I answered yes. I even went to the courthouse to get the paperwork to show that the case actually happened, since USCIS couldn't find any record of it. Then one day, I was home. Actually one morning, and I heard a knock on my door about 5:30 in the morning. When I answered, I saw all these guys in khaki suit and a state trooper. I got scared. I had no idea what was happening. I thought one of my truck might have been in an accident or something. Then I realized it was ICE. They told me they were taking me away because of my marijuana conviction that I reported, even though it was so many years ago. They grabbed me and didn't care that my 11-year-old daughter at the time came out screaming and crying. My wife pleaded and begged, just begged them not to let them take me without not putting on a pants or something, since I was only just in my pajamas and a tank top. I haven't seen my home. I haven't seen my daughter in 10 years. My deportation traumatized her. Her mental health suffered all through her teenage years. She didn't make it to college. Her dreams are mine. It ripped my heart that my daughter was hungry at times and I couldn't do nothing at all. That's my worst nightmare. My son has had trouble with the criminal legal system. I blame myself. I wasn't there when he needed me the most. We were very close. Young men in America need their father. He had just turned 14 when I was dragged away. I'm sorry. As I sit here every day, it has been extremely hard. And it's not just hard on me. It's hard on my entire family. Before my deportation, I fought my case for 2 years from Immigration Detention Center. And it was hard, man. I was moved from one detention center to another, starting in Hampton Roads, York, Pennsylvania, Arizona, Louisiana, New Mexico, and so forth. After I was deported, I got a pardon from the governor of Virginia for the marijuana charge, but I still couldn't come home. The governor told me that his hands are tied and he can't make ICE do nothing. Many people have tried to help me, even the senator from West Virginia, but I still won't budge. Once again, my name is Howard Bailey, one of the many veterans in exile. I love my country, and I just want us to come home. Thank you for listening today. Go Navy!
Thanks, Ellen, for playing that. Oh, and maybe Ellen, if you want to go on mute. I bet there's some ads on that website.
My apologies.
No problem at all. Yeah, so just to give you all who are on the line some context to all of this, and I'll put up some slides in a second, but Howard, what you just heard, Howard's words, he spoke those from Jamaica at the beginning of 2021, when at NIJC, we hosted a briefing on a white paper that we drafted to and for the Biden administration. And so let me just share my screen here with all of you, if you give me 1 second. Can folks,
We see it.
okay, see if I can slideshow. Okay. So Howard was one of 11 people featured in a white paper that I authored with support of many at NIJC called Chance to Come Home. You can see some photos of the various folks we featured in our proposal. And essentially, you know, this white paper offers the Biden administration a roadmap of how they could bring home people like Howard and other deported veterans and other deported people who've been unjustly deported under prior administrations. These are folks who in some cases had incredibly strong legal grounds in the first instance for remaining in the United States, but nevertheless were deported, or folks who were deported and just a couple of months later, there were significant changes in the law from circuit courts or the Supreme Court that meant they would have had a chance to stay. There are also other cases where we've seen, you know, immigration judges and the government abuse the wide discretion it has to decide whether and when to order deportation. So the proposal, you know, details the range of unjust deportations that we feel should be considered in setting up meaningful mechanisms to bring people home. I'm happy, of course, at the end to answer any questions about the proposal itself. Today's training is more about how you all will be helping your clients come home the way that we were able to help Howard. But one, I think, important piece of our proposal that matters for what you're doing as well is to know that under existing law passed by Congress, the immigration system does imagine mechanisms and procedures for bringing people home who were unjustly deported. The problem is that those mechanisms and procedures have rarely worked in practice, and they have rarely been used to redress and rectify unjust removals. So the proposal that we developed really is a way to use existing laws and procedures to set up a central process to bring folks home. So what we are advocating for, you know, doesn't require Congress to do something new. And what all of you will be doing to help deported veterans and perhaps, you know, other deported people in the future will be using existing laws and procedures that exist. So just to kind of circle out on Howard's story, you know, he shared this powerful testimony at the beginning of 2021. He'd been fighting already for 10 years to return, to reunite with his family, to build back everything he lost. We were finally able, with the support of 3 US senators, Senators Padilla, Kane, and Warner, along with support of other folks at DHS, to bring him home in August of last year. Howard testified before a Senate Judiciary Subcommittee. His words were powerful enough to go viral on the Hill, and I was lucky to be at the airport alongside his family and many others to welcome him home after a very long time. And our hope is that in taking these cases and you know, filling out and representing your clients and humanitarian parole applications with our support, that you too will be able to support and facilitate the return home of others who are eager to reunite with their communities and families. So a few things to get started in terms of background and context. And Ellen, can everyone see these slides clearly? Are you still seeing my Zoom screen too?
I see the slide and I see your image. So
okay, so we're okay, right? It
yeah.
looks like Amanda gave me a thumbs up.
Yeah, there you go. You're on track.
Okay, great. I just see, like, that's fine. Okay, so what you'll see here is the cover of an ACLU of California report. ACLU of California is not represented here today, but there's an attorney there, Jenny Pasquarella, who's been a fierce lawyer, leader, and advocate on the work to bring home deported veterans in particular. And this is a report that she co-authored with others that really tells the story of how we ended up in a place in this country where we essentially deported thousands of people who've served in the US military. And And I encourage any of you to look at that report. We sent that around in our materials. But, you know, until recent policy announcements by the Biden administration, what we've seen is a failure from DHS and ICE to exercise prosecutorial discretion in favor of immigrant veterans. So, you know, these agencies have wide discretion in how they make decisions on who to detain and who to deport. And what we've seen, what we saw for many, many years is that there was really no consideration given to the fact that someone had served in the US military when these decisions were being made. So just some background here, how this happened and how this works is that, you know, non-citizen veterans enlist often when they're young men or teenagers, young men and women and teenagers, believing that they would be rewarded for their service with automatic citizenship. And so the majority of folks we're talking about had lawful status when they were serving, of course, and nearly all were eligible for citizenship at the time of their service or discharge. But often, you know, some of these folks erroneously believed that they had automatically become citizens or already were so because, you know, they just been serving in our military and took an oath of allegiance to this country. Other times, red tape in the immigration system backlogged or stalled their applications for citizenship or the process. And then because service members are often moving around from address to address, they often didn't receive in the mail the forms and applications they needed to become US citizens. This coupled with harsh 1996 immigration laws, which essentially created a really very broad set of criminal convictions that lead to deportation, plus Congress's failure to ensure like a clear naturalization process for veterans, essentially meant that one mistake made by an immigrant veteran could be enough to get that person deported. And so what we saw for many years were veterans who were deported based on allegations of criminal conduct that were the direct result of the trauma that they had encountered during their service. So to move us to the next slide, you know, just one example, this veteran Miguel Perez, who made national headlines at the time. I think he was one of the first deported veterans to hit the national news. USCIS, an agency within DHS, denied his citizenship application because of a 2010 drug conviction that he had. You know, he completed his full prison sentence for that conviction. You know, there's no statute of limitations in immigration law. So we see folks who are deported often, you know, sometimes based on convictions from decades prior. In his case, you know, it had been some time, he'd served his sentence, but he was nevertheless deported to Mexico soon after. He had served 2 tours in Afghanistan, and because of that experience had suffered a traumatic brain injury related to an explosion. And this left him with significant symptoms of PTSD that led to his drug addiction and involvement with drugs and ultimately his conviction. And that's what ended up getting him deported. He was ultimately returned to the United States and was given, you know, permission to pursue citizenship because Governor Pritzker in Illinois, you know, gave him a full gubernatorial pardon and a grant of clemency, and there was a ton of advocacy on his behalf. A couple of things to note, you'll see here, you know, there's a 2004 memo explicitly instructed ICE to exercise discretion in favor of veterans when making decisions about deportation. And there was a 2011 memo that offered guidance saying that a person's military service should be considered when PD is being exercised. And what, you know, the ACLU report describes in detail is that it just, this guidance didn't matter in practice, that there were still, you know, hundreds of veterans being deported and put into removal proceedings without consideration of their service to the country. So to, you know, keep us moving here. So Biden came into office in last summer in 2021, some months after we'd released our chance to come home proposal at NIJC, suggesting a centralized process to consider requests for return from unjustly deported people. The administration announced that it would in fact create a central process, but just specifically to support non-citizen veterans who'd been deported. And this was part of an initiative called IMVETS. If you go to the DHS website, you can take a look at that landing page. HB and Amanda will talk more about the IMVETS portal and process for deported veterans seeking return. The initiative is to support all non-citizen service members, veterans, and their immediate family members. It's a collaboration between DHS, Department of Homeland Security, and Department of Defense Veterans Affairs. But within that, there's a team that's focused specifically on reviewing applications and requests from deported veterans who are seeking return. And we will go into a little bit of detail in a bit as to, what does this team look at when they're deciding whether or not to allow somebody to return to the United States. But just to say that until this central process was set up, line level ICE attorneys in immigration court were the only ones sort of considering these requests. And with the caseloads they have, and with the frame of reference they have, which is, a bottom line of deporting more people and getting their dockets clear, we were seeing that very few of these requests for return were even being looked at all. And so a central team like this and process like this is definitely, hopeful and creates opportunity for deported veterans who have been fighting to return to reunite with their families and communities. So to just, get into the weeds of what you all would be working on and helping deported veterans return, the procedural mechanism that IMVETS and the administration uses to bring back deported veterans as of now through this process, through this IMVETS initiative, is humanitarian parole. So, and humanitarian parole is the mechanism that IMVETS is using, but it's a mechanism that is used across the immigration system in a variety of contexts. The definition of HP is in section 212D5 of the Immigration and Nationality Act. And what it essentially does is give the DHS secretary, currently that's Secretary Mayorkas, wide discretion to return people to the US on a case-by-case basis for a broad range of reasons, regardless of that individual's status or other barriers to entry that would typically apply. So in other words, this authority is expansive, and there's not a lot of definition from Congress as to who exactly can be encompassed. And so just to make a quick comment, I'm here in DC on our policy team at NIJC, and what we've been seeing in the past several years is that humanitarian parole is sort of used as a tool by this administration as a stopgap where things are failing, other parts of the immigration system are failing, and people have to be, brought into the country. Humanitarian parole is often the go-to tool because the discretionary authority is so broad and wide. But because it is discretionary and broad, and there isn't a lot of definition from Congress, DHS has a lot of room to make these decisions based on a whole range of things. The statutory language itself, talks about humanitarian reasons or significant public benefit as being the main grounds for which somebody should get humanitarian parole. But, interpretation of those terms are sort of entrusted to DHS and the secretary. There's some case law that defines it a bit, but it's mostly quite open. So more on humanitarian parole, it is designed, as you can tell from that language that I just shared, to be a return for urgent reasons. So emergency medical care, to care for someone who's sick or dying, to get home for a funeral. Often, we've made strong arguments for humanitarian parole in cases where it's someone who needs to be in person back in the US to get post-conviction relief on a criminal conviction that triggered their deportation that would be hard to obtain abroad. A really key thing is that humanitarian parole is limited in time. So typically we're seeing the government grant them for a year, but folks can reapply to renew that period after that 1-year parole period expires. One benefit of parole, right, is that a prior deportation order or prior criminal history do not automatically bar a person from humanitarian parole. So other forms of immigration relief or other pathways to lawful status in the US often have bars. You know, were you deported in the past? How long ago were you deported? What kinds of convictions do you have? Those sorts of things automatically bar someone, and often you have to apply for waivers to get around those bars. With humanitarian parole, most of that just doesn't apply, which means it can be a really awesome tool, a mechanism to help people reunite with their families right away, or to get back to the US so they can figure out a more permanent and meaningful pathway to status once they're here. And then, as I've said a few times now, this decision is highly discretionary, which is why the work that you all will be doing is so critical. It's how we make the case, how we tell the story of each person and why they need to return and what they've lost in, you know, being deported, that strengthens their argument and their application for this discretionary relief. So, and just a few couple of things, and I know HB and Amanda will jump in with things that I may have missed, but, you know, for deported veterans, it is free to apply for humanitarian parole, and that process is now through the centralized InVets initiative, which they will talk to shortly. But immediate family members of deported veterans can also apply for humanitarian parole, but my understanding is that there is a fee associated with that. But important for you to know when you're working with your clients, if they're wondering about their family members, immediate family members are to be supported by InVets and should be able to apply for HP as well so that they can return to the US. And then finally, just, you know, to emphasize to all of you, you know, what does humanitarian parole offer, but also where does it fall short? And this, I think, is important as you manage your own clients' expectations. Obviously, you know, when we talked to Howard Bailey about returning home via parole, the incredibly exciting part of it was the opportunity to possibly, you know, quickly reunite with his family. But then with it came this anxiety of, well, but once I'm back in the US, then what, right? If in a year, will they extend it? What if there's a different administration that wants to deport me again? These are the kinds of questions that folks, you know, have if they're thinking about returning here and wanting to stay, as they usually want to do. And so the thing to flag here, right, is that humanitarian parole doesn't offer that permanent longer term status. And so often in the cases that we're working on for anybody seeking return this way, we are not only taking on humanitarian parole, we are also helping them in their bigger immigration relief case. And often that means filing a motion to reopen their underlying immigration case that got them deported in immigration court, to try to get them the relief they need or change the outcome from that prior case. So just as a quick example, in Howard Bailey's case, his was unusual. He returned home prior to the Biden administration setting up this initiative, or prior to it kind of getting started. And in his case, we filed a motion to reopen his removal proceeding, his immigration proceedings. And because of all of the attention he'd received, the fact that he had a pardon from the governor of Virginia for his, you know, single marijuana conviction, ICE, in his instance, agreed to reopen the case. They also agreed to stipulate to the relief he was seeking to reinstate his green card status. And then because that process was taking a bit of time, we simultaneously filed a humanitarian parole application that allowed him to be paroled back into the country while the remainder of that process was completed. But often, in many of these instances, as HB and Amanda will likely describe, we can get people paroled back in through IMVETS, but IMVETS is not offering them an agreement to reopen their case or to give them relief the way that we were able to secure in Howard's case. And so in some instances, these cases requires, significant amount of more work. But what we are training you on today and what we're hopeful for in developing this partnership with you is to have you all just fill in at the very least, and most importantly, on the humanitarian parole front, because that is the priority mechanism to bring people back. So with that, I'm going to turn it over to HB, and she can, they can fill in anything that I missed on this front, and then I think we'll walk us through next, the nuts and bolts of how you put together these applications, and I'll close us out at the end with some next steps. Thanks, HB.
Yeah, thank you, Nina, and thank you everyone for joining us today. I also have a PowerPoint, which I'm going to share. And my colleague Amanda is going to be sharing this with me, but she has a little family minor emergency right now, so I don't know if she will, I might just be filling in, so we'll see. Okay, so can everyone see the PowerPoint? So.
Yes, we can see.
Thank you. So we'll start with the application, like the actual application and supporting evidence that that was needed to put together the parole application. So there are a few required documents that IMVETS, and this process is pretty unique to the IMVETS for deported veterans or their military families. If you're thinking of applying for humanitarian parole for somebody else who's doesn't fall under IMVETS, who's not a deported veteran, then it would be a little bit of a different process. Just keep that in mind. So the required documentation, as your attorney, as the attorney, you'll be entering an appearance with Form G28. You'll also be required to fill out the actual application for the travel document, which is Form I-131. And you'll need to submit some supporting evidence, which we'll get into. What's also required for these parole applications is a declaration of financial support, which is found in Form I-134. And this is will need to be filled out by somebody who has some connection to the veteran and who has status in the United States and some sort of financial cushion or some source of income, who can submit this documentation and accompanying financial records to the United States government, kind of pledging that they will support the veteran if needed. No actual support is required. It's just kind of like a procedural requirement to just show that there's somebody there, that the person will not become a public charge. So that's that form, and we'll get into kind of what evidence is needed for that. And specific to deported veterans, there are two forms that more recently IMVETS has started to require for these cases. That's two forms of releasing information or having the vet agree to release medical information between the VA and DHS. I've had cases approved without these forms if it's not relevant, if like the person's medical history or medical needs is not relevant to the case. But if the client is okay with submitting, with granting this access to their medical history, then it's like best practice to include. So we're going to go over some supporting evidence that's needed for the actual application for parole. So this is really, I included in here some examples of things that you might want to include. It really takes looking at the individual client's case to determine what is needed in that to support the request for parole. So oftentimes we see folks who are seeking parole for health-related claims. A lot of people don't have access to healthcare, or it's really expensive. They don't have health insurance in their current country. And so, but they would be eligible for medical care through the VA system in the United States because of their military history. So that's a really common thing that we're seeing, especially some of our older veterans. And so providing proof of getting that the veteran would be able to access medical care through the VA, like through a disability rating or some other communication with the VA. Medical records, doctor's notes, things that show what the scope of the medical needs are, and what surgeries are required, things like that. Sometimes these documents are really hard to come by because of access to medical systems can be really limited. So I also included here some alternative things that you can think about, like letters from family and friends saying, I know my brother has had a heart attack a few years ago and he really needs care and he just hasn't been able to afford it, things like that. And as Anna mentioned, this IMVETS also allows for is reviewing cases of family members, immediate family members who are seeking repatriation, family members of veterans. So if it's for a family member, you'll want to include evidence between the vet and the family member. Like evidence of relationships. That could be a birth certificate, a marriage certificate, things like that. This would be the same thing for a family member. If the person is seeking repatriation, a veteran seeking repatriation to visit with a family member in the United States who's ill, you'd want to include this evidence as well as an evidence of their relationship. Something else that we've been seeing are people who are really experiencing a lot of safety concerns in their current country. Sometimes these are related to the person's prior military service. If they have really visible tattoos, like military tattoos, or if they're in a small country or small community and their prior military service in the United States military is well known, people can face harassment and some extreme violence. So we've had a few people repatriate through this because of their safety concerns. And these can be a little harder to prove. Oftentimes there isn't witness statements. So letters, if you have witness statements, great, of the people who've witnessed incidents of violence, things like that, that's fantastic. If not, then letters from family and friends, possibly in the United States, who have heard about what's happening to their loved one. General country conditions reports about if there is civil war, or there are there's documentation of violence against deported people from the United States, just in general, even if not specifically about vets, things like that. And then we're going to talk about a declaration in a little bit, but you could also think about including a short declaration from the veteran specifically about the safety concerns. And then there's general family reunification. So, if the person has young kids in the United States or hasn't seen their family in a really long time, we've sometimes seen IMVETS grant parole in those instances. So you can include letters from family and friends. Drawings from young kids are often really pull the heartstrings, but you'd also want to include birth certificates or other evidence of the relationship. And I didn't include it on here, but I think it was mentioned earlier, parole for the purposes of trying to seek some sort of legal, immigration relief or criminal, post-conviction relief in the United States that they couldn't access or be difficult to access outside of the United States is also something that we're requesting parole for. So, we can, with your particular case, you might know about what type of immigration relief this person might be eligible for. You might not. But we can talk together about the specifics of the case. So about like what might they be eligible for, what they could access in the United States that they might not be able to access outside the United States. So this page is like, really tailored to the specifics of the particular client situation. This page includes some general things that you would want to include in all applications. So passports are pretty much required in all situations, except for in some cases if they're crossing through the lands border, but it's best practice to make sure your client has a passport. That's generally one of the first things that I talk to my client about when I'm establishing representation is, do you have a passport? If not, make an appointment right now, because that will be really necessary and just make the process go a lot easier. You'll also want to make sure that your client has evidence of their military service. Otherwise, it will be really difficult to proceed down this path of getting IMVETs to look into the case without some evidence of military service. So if you served in active duty, you are discharged with what's called a Form DD-214. If you were in the reserves, you're discharged with Form NGB-22. And your clients should know what these are and should know whether they have a copy or not. If they don't have a copy, maybe their family or friends in the United States have a copy. And if not, you can request it from the military. But that's another thing I would talk to them about pretty soon after your first conversation so that you can make those requests if needed. Other evidence is recommended to include any evidence of like VA benefits that are available in the United States if the person will be paroled in, support letters from family and friends, family photos, evidence of rehabilitation, which is something that we're seeing a lot of requests from IMVETs coming back to us a lot, asking for more evidence of rehabilitation. And especially in cases where the criminal history might be more serious or lengthy or recent. So again, this actual evidence that you submit is really going to be tailored to what your client's criminal history is, if any, and your client's current situation. But here are some examples. If your clients completed any rehab programs, either in their current country or when they were like in prison in the United States, anything like that, then you'll want to include evidence there. If your client has like a past addiction history or lots of past drug use that's known in the record, like if it's, a conviction is because of drug use or something like that, then you will want to consider including recent drug test results to show that the person no longer has drugs in their system, they're not using, they're in recovery. If the person is currently employed or is in school or is like involved in any other sort of like local community organization, things like that, showing that the person is involved in their community, has a steady job, things like that. A big ask that we're getting from IMVETs is to include police clearance letters from their local government. This really can vary country by country of how easy these are to access. In some countries, like in Mexico, you can go to a local police station and request a letter saying that you don't have a criminal record. But in other countries, it could be a little bit more difficult to do that. So the last two are kind of the same here about declarations. So if you don't have a lot of other evidence, or you really need to explain why, like contextualize your client's criminal history, if it came from PTSD, really struggling to adapt to civilian life after serving in the military, or something else is really happening in the client's life that can kind of give the fuller picture of what is on their rap sheet, then you might want to consider including a declaration. This can be tricky because you don't want to speak to anything that they could be impeached with later. And so you don't want to raise any credibility issues if there's anything that, comes up during that could come up during a naturalization interview or another type of immigration relief application in the future. So making these declarations brief, speaking just to like rehabilitation or like context of something that happened in the past, but not going through their whole life story is kind of how I would approach that. And Amanda, I don't know if you're here, but if you have anything you want to chime in on that point, you're welcome to. Oh, great.
Sure. Sorry, I had to run away from the computer for a second. My dog got out and we recently moved, but all is well. He's back. So for a lot of people who have been deported for a significant period of time, their rehabilitation or evidence of rehabilitation may not be, what we consider traditional, any type of class, any type of community service programming. It may be that someone's been deported for 20 years and they now have a family, they're a parent, they can speak to, how they support their family, how they support their children, that they have, even if they don't have evidence of all of the work that they've done, you might not get pay stubs, things like that, they can speak to that in their declaration. A lot of people tutor English on the side after they've been removed. Things like that are all evidence of rehabilitation that doesn't come in the form of a certificate, they may be able to speak about classes that they took if they were incarcerated in the United States that they don't have records of, and how to utilize some of the methods that they learned in those classes, such as deep breathing when a difficult situation arises. Those are things that can be written about in a declaration where someone just doesn't have the other evidence. And it's going to need to come into play, especially if there are convictions where the statute criminalizes crimes against another person. So like HB was saying, be very careful with what you put in the declaration, because that can always be measured against any future testimony and bring up credibility issues. I would not get into the facts and circumstances of any criminal history unless you have the entire criminal defense file or the court file or both. So you know exactly what documentation exists out there, because if someone has a path to apply for naturalization, relief, and immigration court, DHS will have access to those documents, and you don't want anything in the declaration that conflicts with that. So the declaration really limited to the rehabilitation. Noting, yes, you can note past wrong behavior. I've made a lot of mistakes in my life. Can keep it simple like that. And this is something that I really would consider in cases where there's really not other evidence of rehabilitation available. And in that case, you can also speak to family and friends to include that type of information in the declaration. I've seen how they've changed over the last few years. The type of conversations that we have are different. A lot of people are available to speak to those things that we just don't think of traditional rehabilitation. And it can be, really frustrating for people to bring this up. So just being aware of that, because we do have a lot of combat veterans who are deported and their PTSD as a result of their combat experience, which led immediately after they were discharged from the military to some criminal convictions and a deportation, that then they cannot get any services of rehabilitation that they're entitled to through the VA in the country where they are. So just to note that, bringing this up as a need can be a sensitive topic. So consider that when going into the conversation with anyone.
Thanks, Amanda. I'm glad you found your dog. Okay, so for the I-134, which is the Declaration of Financial Support. So this is something that's filled out by, well, there's two options, which I'll go over. The recommended approach is having an actual sponsor, somebody in the United States with some legal status here, fill out the application for the Declaration of Financial Support for the veteran. So the other option, which I'll go over in a second, is if the veteran is able to support themselves while they're in the United States. This option is only available if the veteran has financial, like a proof of like means of income or a lot of assets that will continue once a person is in the United States. So if they have a really cushy job in their current country, but they're not going to be employed while they're in the United States, then, or they're not going to have that job while they're in the United States, then it doesn't really make sense for them to say that they're going to be supporting themselves when that's not, they'll have to apply for work permit and things like that. And that job won't transfer to the United States. So the real recommendation is to have a veteran use a sponsor. Oftentimes it's a family member, sometimes it's a friend. Occasionally it can be like an organization or somebody that doesn't know the veteran who just like wants to help. So in addition to actually filling out the form, and there's an example of how to fill out the form on the parole guide, you'll want to include some documents, supporting evidence, financial documents, such as recent pay stubs, recent tax return, bank statement, other proof of assets, and you also need to include a copy of your sponsor's ID, preferably a passport, or if they don't have one, a driver's license. And if the vet really doesn't want to use a sponsor, but wants to, say that they're going to support themselves, they'll have to provide proof of income that the vet received while they're in the United States, a most recent tax return, bank statements, other proof of assets. And just to note, I'm not sure if I included this in a later slide or not, but veterans are, repatriated veterans who are coming back on humanitarian parole are eligible for a work permit. That application is pretty straightforward, but it's not something that they can apply for until they're in the United States, until they've already been admitted to the United States. So that is something that you'll want to make sure that they are aware of, that there will be some time before they're able to work here lawfully. Okay, I think it's you, Amanda.
So the nuts and bolts of filing the application, once you get through the document gathering, which is really the most important and extensive part. So filing the application, I realize we should have linked the memo here, but maybe we can put it in the chat that the administration released that no veteran will have to pay fees associated with the naturalization application. I'm actually not sure if the parole is in that memo. It was the Veterans Day memo, but there is no fee for veterans applying for humanitarian parole. But you need to write where it says on the top line, either IMMVI, Immigrant Military Members Veterans Initiative, or IMVETS, and then veteran application on the application envelope and cover letter. If it's not on the application, the form I-131, and it gets rejected, they will not receipt it from that original filing. You'll have to resubmit the filing. So, and if it's not on the cover letter, you could risk having it incorrectly rejected. In that case, they probably would attach a receipt number to that original date. But best practice to put it very obviously on the cover letter, on the application itself, the form, and on the envelope. So mailing it to the USCIS IMVETS lockbox, the humanitarian parole lockbox, and then email the IMVETS email address when you send it. That way, there have been incorrect rejections, but if you email them with the receipt number, they'll make sure it doesn't get incorrectly rejected. Even when it's the IMVETS is written in bold and red and highlighted, that we have gotten rejections incorrectly for no fee. Because the people processing the applications at the lockbox aren't the IMVETS staff themselves. They're USCIS employees. And you can update the IMVETS team. You should update the IMVETS team when you do receive the receipt notice and the receipt number. And they can sometimes assist if there is a biometrics notice with getting an appointment set up. If an RFE is sent, a request for evidence, then you can respond to that request for evidence via email, which I don't know if anyone has immigration experience on this call, but normally anything filed with USCIS is received and submitted via mail. So the ability to submit it via email is a lot easier. But we have been seeing more RFEs recently, and where the application isn't complete with the documentation that we've discussed on this call, particularly where there is a more extensive criminal history. So just do everything you can in preparing the application to address the public safety and national security concerns. Are there any? And the documentation, I think, as the initiative has been receiving more and more applications, they're looking for additional documentation than they may have in the beginning of the existence. So once the application has been received by USCIS, the INVETS team will, the INVETS team don't actually adjudicate the application. For anyone who's been deported, ICE has jurisdiction over that. So they will share that application with their counterparts in ICE, and they will be the liaison though to send any requests for evidence, and we would follow up directly with the INVETS team. So once you are ready to file, I mean, there could be issues that come up beforehand that you might want to submit an inquiry on the portal. If you need records requests that's expedited to submit a request for humanitarian parole, you can use the portal for that reason. But there is a portal for the deported veterans. It's listed there. You can submit an inquiry on behalf of your client, and if someone is represented, I would recommend the attorney submitting their information as the contact. For the reason I noted on the 4th bullet point, when you do submit an inquiry, it's going to generate an auto response saying, so if you put in there something, I want an update on my humanitarian parole application, an auto response might be update on your humanitarian parole application, which can be really confusing because there's a lot of text in those emails to make people think that their application is approved, or if they get an RFE, they think all I need to do is submit a copy of my passport and my application is going to be approved, when it's really asking for additional evidence to then further review the application. So for submitting, the portal entry creates a case within the INVETS team. So I recommend, if you haven't yet, by the time you're filing, to submit that inquiry through the portal at that time. And I think that's it for the slide. So repatriation. This, after a humanitarian parole request is approved, a lot of people coming back from Mexico are going to be coming through a land border because it's much easier and quicker to repatriate once that parole has been approved. So the INVETS team will email you as the counsel the parole approval letter, and then we provide those to our clients directly and tell them to print it out. At this time, deported veterans have been repatriated through the port of entry at San Ysidro in San Diego and in Ciudad Juarez, because the INVETS team has developed relationships with those two offices. If you want your client to enter through any other port of entry, you need to get on coordination for that very early in the process, because it will take a lot longer than you might think it will to coordinate that. If they are going to enter through San Ysidro or Ciudad Juarez, then the INVETS team can help coordinate that date of entry, and it can be within a few days of receiving that parole approval letter. HB, I don't know if you have a different experience, but in my experience, when I get the parole approval letter, it's usually starting a parole period the following day. So people really do want to enter as soon as possible. And to streamline that, we'll say, I'm going to come through San Ysidro, even though I'm going to Michigan or elsewhere, because it's the fastest way for me to actually be with my family. It is possible for the InVets team to change that period of parole. But so I would consider, if you have a parole approval, whether it's worth it to try and coordinate for a different port of entry. Oh, and HBS had a client come through the Peace Bridge in Canada, though probably entries from Canada are going to be less common. And although the InVets team will coordinate with CVP at the port of entry, even at the San Ysidro port of entry, we have had the situation where the officers who are actually on the ground processing the parole weren't notified of the appointment day at time, and it just makes you have to wait a few hours longer. So calling the CVP office at the port of entry, even if it's San Ysidro or Ciudad Juarez, just to verify that the officers on the ground are going to be aware of that entry. And also just to point out, although parole is approved by ICE, CVP does have ultimate jurisdiction over whether that entry will be allowed. At this time, we haven't come across a situation where someone has been denied entry after an approval through the InVets process, but it is always a possibility. So it's important to understand that and make sure that clients do understand that as well. We do recommend that if someone can cross through with your client, because the wait can be quite stressful. People have to wait outside of secondary. If someone's crossing through with them, they can wait with them outside of secondary, and it's, you know, obviously an extremely emotional process, the repatriation, and it's great to have support there. If your clients do have contacts within the deported veterans community, for a lot of our entries, we've had a group of people come to meet at the border. The VFW in San Diego is really active. Sometimes they come, bring some flags, supportive community for that ultimate repatriation, because it is, you know, as expected, a lot for people to process. And
just on that point, sorry,
go ahead.
if your client has medical needs, you will want to make sure that you're coordinating with InVets ahead of time. Like if they need to use a wheelchair when they cross, or if they can't stand for long periods of time, if they will need to bring certain medication or things like that, it's always a good idea to flag that for InVets ahead of time, because as Amanda was saying, the repatriation actual process being processed by CBP can sometimes take a while, and it can be really stressful, especially if somebody is experiencing has a lot of medical needs, to not have support, or at least somebody there to be with them.
Absolutely. And for coordinating those travel plans, we have had clients who have missed their travel plans because one client whose appointment was at 8 in the morning had a 1 o'clock bus. He did not make the bus. So that was very stressful for him. So I think in a lot of cases, same day travel would work out, but if, you know, just be aware, the longest we've had to wait is about 4 or 5 hours, but again, you never know. So next slide. So repatriation through the air is a lot more expensive process, and, you know, airlines are involved, and airlines will get fined if they allow someone on a plane without proper travel documentation. So an airline is not going to let anyone on the flight without that parole approval letter. Excuse me one quick second.
I'll chime in. So to repatriate the airport, you'll need to receive Are you back, Amanda?
Sorry. So you'll get the parole approval via email, same as you will for a land entry. At that point, you need to start coordinating with the INVETS team to schedule an appointment with the U.S. Embassy in the country where your client is currently. And that's going to look a lot different for every country. The speed at which INVETS is able to coordinate that appointment, whether there is a contact for us as attorneys to try to reach out to facilitate that. However, even if we are able to get a hold of the consulate as the attorney, they're not going to schedule an appointment, when we're telling them that parole has been approved. That's my experience. They're going to want to hear that from a U.S. government official. And it's the ICE officers within INVETS that have done that in the cases that I have worked on. And it has taken about a month to coordinate from the time of parole approval to getting the clients in the country. But I have seen it take longer where it is more difficult to coordinate with the embassy. So this is something that it's really important to do early and quickly. Once the appointment is scheduled, it has to be 7 to 10 days before the travel. They need to bring passport style photos, the parole approval letter, and their travel itinerary to the appointment. And then the parole is put into the passport, same as a travel visa. I think that is easing the transition. So once parole is approved and the entry has happened, you can apply for a work authorization. It's Form I-765. INVETS is expediting these. So once that's been submitted, and the application itself is pretty simple. So, of course, that's most people's very first question. So getting that submitted ASAP, letting INVETS know so they can expedite it. Again, needing to put that MV or INVETS veteran application so there's no fee on the application, cover letter, and envelope. Getting VA benefits. The INVETS team does have some points of contact, so within different local VA offices. Getting some form of ID, Social Security, housing mentorship, and then I do think it's important to speak with clients if any of your firms have the capacity to assist with transportation or accommodations if there's not going to be same-day travel to the final destination. A lot of vets aren't going to necessarily have unlimited funds or many funds to support that, especially before they connect with their family or support system in the United States.
All right. Okay, so we're a little short on time here, so I'm just going to jump in. Thank you so much, HB and Amanda. And just, for all of you on the line, this is recorded, so you can always go back and listen to all of the information they've shared here. We've sent you a ton of resources. So a few quick things that I wanted to say. One is to just share that, just so you have some quick context, that of the 80 requests that have been made to INVETS, 31 or so have been granted for folks to return. So just to say, this work is so critical. And I think what we're seeing is just a dire need for representation in humanitarian parole applications across the board. I get probably 2 to 3 calls a week from non-veterans folks. So building out your expertise here is incredibly invaluable as we hope the administration continues to do this. What you'll see in front of you is a QR code for any of you who are needing CLE credit. You can use that to fill out a survey that's necessary to get that credit. But most importantly, in terms of next steps. So we have a small list of cases that are already lined up and need support right away. And I know, we've already had some conversations with Perkins about these cases and with You know, the other two firms here today, we're happy to follow up with this to see how we may be able to place some with you all, depending on your capacity and availability. You know, we'll just reach out to you after this to have that conversation and share the write-ups of those cases. Just flagging for all of you that, you know, we're the three of us are here to support and offer technical assistance on these cases. And so, you know, we will be working with you directly depending on which cases you take. And then we didn't have a ton of time for questions today, so we're more than happy to field those by email. I'm going to just share my email here in the chat right now so that folks can feel free to directly email me and then I can loop everybody in. But of course, like if you want to put in anything into the chat right now, we can follow up off of the chat. But, you know, again, grateful to all of you for being here and for hopefully being able and willing to jump in on these to help individual folks returning, but also to just start building up some experience and expertise as we start to see more of a need for this kind of representation. So I think that puts us right at 5:45, which is our end time. But if anybody wants to stay on, yeah, we will share the recording and slide deck. Thank you so much. I'm happy to hang on here for just another 2 minutes as folks jump off in case there are questions that people have. And it looks like Amanda's nodding, so maybe she can stay with us in case people have questions. So thank you all so much. And thanks, Ellen, for organizing us.
I'm going to stop the recording.
Okay, great.